announce it and we will pause the proceeding and clock. The dropped individual should attempt to rejoin as quickly as possible. Please contact me or Sarah Carr at the number on the court sheet should you have any trouble reconnecting. Judge Wilkinson, can the courtroom deputy open court now?
Yes, please.
Thank you.
The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, counsel. We are prepared to move ahead with 19-1209, Hickson versus Moran. And Ms. Catalina, we'd be pleased to hear from you.
Thank you, Your Honor. May it please the court, my name is Catherine Cantalina and I'm appearing on behalf of appellant Carrie Hickson. First and foremost, this court does not have jurisdiction to hear this appeal because the district court has not issued a final judgment. Our client's claim is not that he was deprived of insulin, it's that he was denied medical care for his diabetes. In ruling solely on the issue of Dr. Moran's denial of insulin, the district court ruled on only one of the multiple modalities by which Dr. Moran could have rendered care. Moreover, the district court committed 3 points of reversible error when it incorrectly applied the standard of summary judgment, when it incorrectly stated the law on deliberate indifference, and erred in analyzing Hickson's gross negligence claim. I'll first discuss this court's lack of jurisdiction and then the 3 points of reversible error from the district court. This Court of Appeals does not have the jurisdiction to hear this case because there are still live, unresolved claims at the trial level because the district court failed to analyze Hickson's claim that he needed oral medication. An order is non-final if a district court has not adjudicated all of the claims in a case. Moreover, under Hemingway v. Chapman and Davis v. Bishop, both cases decided by this court, an order is non-final also when a district court fails to address a claim in its entirety. In Davis v. Bishop, the Court of Appeals had no jurisdiction when the district court analyzed only one fact pattern under a legal theory, but omitted the analysis of the second fact pattern under the theory. In Hemingway, the district court construed the plaintiff's Bivens claim and medical malpractice claims as relating only to the denial of insulin. That's most similar to this case where the claims were properly construed as relating to the denial of insulin, but also another injury that the plaintiff received. Because the district court analyzed—
Well, why wouldn't the claim here be simply a failure to treat the appellant's diabetes? I mean, the district court did address that.
Thank you, Your Honor. So the claim here is, it is a claim. You're correct that it's a claim to not treat, of a failure to treat diabetes. But the issue is that the district court only addressed in its opinion one of the methods by which diabetes could be treated. And so in—
but I mean, we're going to be driving district courts crazy if we try to go at these things medication by medication. I mean, all of these claims have factual subsets to them. But the question is whether the district court really addressed the claim as a whole. And what you were claiming was that there was deliberate indifference in the failure to treat diabetes, and the district court addressed that.
Your Honor, it's our position that the district court didn't address it, not because necessarily the issue is that it didn't address each type of medication that was failed, that Dr. Moran didn't provide. It's more an issue that he didn't address one of the major claims from our expert, Dr. Roop, who testified that an oral medication such as metformin should be provided. So the issue is that what the district court said is that Dr. Moran stated a rational reason for not providing insulin. And his rational reason that was based on Mr. Hickson's fluctuating blood sugar levels.
Why wouldn't the district court concentrate on insulin, for example? Because if you read Hickson's deposition, it stresses insulin. So the district court would naturally stress that. And the district court did address all the medications. It didn't address insulin. The question is, was it wrong in putting the emphasis on the insulin? And I'm not sure that it was wrong to put the emphasis on the insulin when Hickson himself put the emphasis on the insulin.
Sure, Your Honor. Our position is that the issue isn't necessarily emphasis so much as the district court did not provide a reason that he wouldn't have given Mr. Hickson oral medication at all. There's no reason that he should not have been given metformin if there was a concern.
This is Judge Freshing. I'm not sure that that's correct. The way I read the district court opinion, the district court concludes that the doctor did not have the requisite state of mind and took some action. Why doesn't that reasoning cover insulin, other medications? It seems like it would cover everything that Mr. Hickson claims he should have received. The court wasn't going medication by medication and saying this is reasonable, this was not. Rather, the court said the state of mind is missing here, and the doctor took some action, and that would appear to cover every permutation of your client's claim.
Sure. So, Your Honor, our issue here is not necessarily as to the issue of jurisdiction. We're not really talking about the culpable our argument is not about the culpable state of mind as to the subjective prong of the deliberate indifference claim. I could talk about that. That's one of the points of error that we.
But doesn't that resolve every part of the claim? And so whether the judge specifically said this applies both to the insulin state of facts and to the other medication state of facts, we can look and see that the court's reasoning was sufficient to dispose of the entire case. So doesn't that render it a final judgment?
I suppose I would direct Your Honor to Hemingway v. Chapman, where the issue of these two separate injuries this court still said that there was no jurisdiction where both of the separate types of treatment were not addressed. So in short, you have an issue where you have a plaintiff who's bringing a claim, and the claim is not necessarily for the denial of one specific medication. It's not broken out into denial of insulin and denial of metformin so much as the subjective state of mind that caused him to, okay, this was his reason for not providing insulin, but also given that the blood sugar levels were continuing to rise and his A1C level was continuing to rise, what caused him to not provide some sort of alternative treatment such as metformin?
I don't understand why the gist of the thing isn't right here before us, front and center, because when you say, well, he was deliberately indifferent, and this really relates to Judge Rushing's comments, but when you say he was or was not deliberately indifferent in the face of the claim of treatment of diabetes, if you're making that claim, the deliberate indifference would cover the full course of care, one medication as well as another, one possible route of treatment as opposed to another. One thing I'm concerned about is simply hectoring and harassing district courts with an endless series of remands. As far as I could say, this was a very conscientious district judge who addressed this claim very conscientiously.
Sure, and as to the claim of deliberate indifference, it's our position that the issue was not sort of failing to address one versus another, and we certainly don't want district courts to have to be in this position where they have to run down every single medication that wasn't given. Our issue is that it created a triable issue of fact. The district court, in fact, erred in analyzing the subjective prong of the deliberate indifference standard. The Constitution.
Well, it might have created a tribal issue of fact if the standard had been one of negligence. And what you have here are dueling experts. Oddly enough, the plaintiff's expert never practiced in a prison facility, and plaintiff doesn't even seem to acknowledge the testimony of the defendant's experts. But when you have a battle of experts, that would be enough to establish perhaps an issue of triable fact if the governing standard were one of negligence. But I don't think we've ever held it a battle of qualified experts, and surely the defendant's expert was qualified under Daubert. But a battle of experts doesn't generally establish an issue of triable fact under deliberate indifference. It would maybe under negligence, but the deliberate indifference standard is there for a reason, and Estelle v. Gamble, which is the fountainhead case for all of this, stresses that it's deliberate indifference because we don't want these claims to just proliferate. And what has happened here is that the deliberate indifference standard has over the years been, in some instances and in some quarters, diluted and watered down into a negligence standard, and that's not the direction the Supreme Court hoped it would go or wanted it to go. And too often this happens, is that this standards of review that the Supreme Court promulgates in a limited fashion come down here and they get expanded and diluted. And it seems to me that's what happens here if you take a battle of experts, one of which was clearly qualified, the other of which had never practiced in a prison facility, and you say, oh, well, that creates a tribal issue over deliberate indifference. I don't get that.
Sure. So, Your Honor, I think that we're now sort of talking about the standard of a reasonable action, because under the Farmer v. Brennan test, the district court did acknowledge that the harm was sufficiently serious. As to whether the actions that they took that Dr. Moran took in the face of that harm were reasonable, even if the harm was ultimately not averted, the following issues we say.
Oh, isn't reasonableness a negligence concept?
Well, this is under Farmer v. Brennan. The two prongs are, one, that the harm was sufficiently serious, two, that the defendant had a sufficiently culpable state of mind. But as Farmer v. Brennan said, even if both of those prongs are met, if the defendant...
How can it be deliberate indifference when there was Dr. Moran ordered tests as to blood sugar and ordered a diabetic diet to be instituted? And you may not agree with the course of treatment, but how can it be deliberate indifference?
Well, Your Honor, we believe that the adding the tests as to blood sugar, if anything, run to his state of mind under the second prong of Brennan, showing that he appreciated a substantial risk of harm, but that he did nothing. We have a plaintiff's excerpt who says that
deliberate indifference means the intentional disregard of a known risk. And I don't see that in Dr. Moran's activities. It's highly debatable in diabetic treatments whether one gives insulin and when one gives insulin. And you've heard of side effects, haven't you?
Yes, Your Honor.
And those go with any prescription medication. And if you give, and I think this is fairly general knowledge, but if you give insulin when someone's blood sugar is really low, that leads to hyperglycemia, or it can. And the symptoms of hyperglycemia range from uncontrollable shakings to a disruption of heart rhythms and heart palpitations. And in the most serious cases, which are a minority admittedly, but they are there, insulin can induce a coma if it's given under the wrong conditions. And so you have a prison doctor who's fairly cautious and says, look, I want to, to the degree that I can do anything, I'm going to monitor the blood sugar level and order diabetic diet. If he'd given the insulin and there have been untoward consequences, we'd have another lawsuit. And it would have been a far more serious one than this.
Sure. Yes. Sorry, I wasn't sure what that sound was.
Go ahead.
Okay.
You may finish your thought, Ms. Cantalina, please.
Sure. So, as to the insulin-inducing hypoglycemia, that is why other oral medications exist, such as metformin. Thank you. I conclude my time.
I've taken some of your time, Ms. Catalina. I want to make sure you've had a chance to get your argument, so please continue.
Sure. Okay. Thank you. So it's our position that the district court misapplied the standard of summary judgment and deliberate indifference. And I wanted to just briefly list for you all of the facts that demonstrate a triable issue that Moran actually appreciated a risk of serious harm. So 1, Hickson's blood sugar was checked every day. These records were reviewed by Dr. Moran and the blood sugar level continued to rise. 2, the record indicates his A1C was rising too, topping out at 10 actually. In December, upon reviewing Hickson's blood sugar readings and noticing that they were rising, Moran actually ordered that Hickson's blood sugar now be checked twice a day. And 4, in his deposition testimony, Moran stated he was aware of the negative effects of untreated diabetes on a person and the long-term potential negative effects of leaving the disease untreated. I'd also just like to briefly go into the following facts that create a triable issue as to whether Dr. Moran's activities rose to the level of a reasonable response under Farmer v. Brennan. 1, his alleged response that was reasonable was that he claims was reasonable was putting Hicks on a diabetic diet, but evidence suggests, and our plaintiff's expert suggests, that this was not working because the blood sugar levels continued to rise. 2, Moran claims he didn't provide insulin because he was afraid that the blood sugar would drop too low. This is
let me ask you this. On page 26 of your opponent's brief, they say, and I'm quoting from it, the undisputed direct evidence shows, quote, that Hickson never complained of symptoms related to diabetes, never submitted a single medical request form related to diabetes, yet managed to do so at least 12 other times for other reasons, never requested to see Dr. Henson for his diabetes, never filed a grievance related to his diabetes, and in his one meeting with Dr. Hickson did not raise the issue of diabetes at all. Now that's what they're claiming on page 26 of their brief, and I wonder how you would respond to that.
Sure. Well, Your Honor, Mr. Hickson did complain to the nurses of his blood sugar, and he did plead for insulin. So in the time that he actually went to go and see Dr. Moran, the time that is alleged where he said that he didn't want to get treatment for his diabetes, what happened is the doctor asked him how his diabetes was doing, and he said that he was here for his back pain. At that time, the issue with his back was predominating. But he did plead multiple times with the nurses to get treatment for his diabetes. and no treatment was had. Moreover, under the deliberate indifference standard, a risk that is sufficiently obvious, this runs to a risk that is sufficiently obvious can create an inference of the knowledge that is necessary under the subjective prong of the deliberate indifference standard. So it is our position that the risk here was sufficiently obvious to create an inference and at least show us at the end of the day, you know, we'd like this to go before a jury. We'd like Mr. Hickson to have his day in court, and we'd like him to have that because we believe that we have presented multiple triable issues of fact that the district court disregarded.
All right. Well, thank you. Thank you very much. And I'm going to, before you go away, I want to, and you've got some rebuttal time too, and I'm going to ask each of my co-panelists if they have any further questions of you. Judge Traxler, Judge Russing, do you all have any questions of Ms. Catalina?
Judge, this is Judge Traxler. I have two questions I'd like to ask her.
Sure.
Ms. Catalina, I have two questions. The first one deals with the question of whether or not the district court issued a final judgment. The question is this, the situation is this. We see a number of orders from district judges, district courts, and we issue a number of orders ourselves where the court addresses the main issue in the case, and then as to other issues in the case, we simply say we have considered the other issues in the case and we find them to be without merit. And there's no discussion beyond that, no comment beyond that. If a district court issues an order like that, is it your position that that's not a final order? And if it's not, would you please explain why not?
No, Your Honor, it's not our position that that would not be a final order. The issue here is that the district court didn't say we have considered the other issues and we consider them to be without merit. It was never.
So that's all. So that's all that needs to be said then.
Yes.
Okay. Now my second question deals with Dr. Roop's opinion. When I read her report and her testimony, she said very clearly that it was her opinion there was negligence on the part of Dr. Moran, but I didn't see where she said it was more than negligence, that is deliberate indifference. Did I miss something? Is there a page number or site you can give me that would show that?
Your Honor, I don't know if she, you know, our plaintiff's expert is you know, a doctor. I don't know if she used specifically the term deliberate indifference. We assert based on her testimony that it's deliberate indifference because there was a subjective awareness of the serious, because there are facts which indicate a subjective awareness of the serious harm on the part of Dr. Moran, and facts which indicate that he did nothing in the face of it.
Well, you say that, but she doesn't say that, does she?
Sure. I mean, Your Honor, I don't think that she really would be specifically qualified to say whether legally there was deliberate indifference.
Okay, thank you, Judge Wilkinson.
Yes, Judge Rushing, do you have some questions, further questions you'd like to ask?
I don't, thank you.
All right. Well, let's hear from Mr. Dadak then, all right?
May it please the court, Chris Dadak on behalf of Dr. Moran. Briefly, I would like to address the jurisdictional argument. Throughout its opinion, the district court repeatedly properly frames the claim as deliberate indifference to a serious medical need for diabetic medication, prescriptive or otherwise. The district court consistently frames the claim that way and includes the fact that Dr. Moran did not prescribe any medication or insulin in his recitation of the material facts. So throughout the opinion, the district court correctly frames the claim as deliberate indifference to a serious medical need and includes insulin or other medication in its analysis. The district court then correctly granted summary judgment. Again, this is on summary judgment when the plaintiff has had an opportunity to go through discovery, develop a full record. The district court correctly analyzed the deliberate indifference standard. And I'm sorry, Judge Wilkinson, your box lit up and I thought you were going to ask a question. I didn't want to interrupt you.
No, I was not going to, I'm sorry, I didn't mean to interrupt, and I don't know who's in control of my lights, but I did not have a question. You please proceed.
Yes, Your Honor. In big picture wise, the reasoning for district courts is obvious. Hickson never complained of symptoms regarding his diabetes. Yes, he did request insulin, but he never complained of symptoms he attributed to diabetes to his nurses. He filed at least 12 inmate request forms for non-emergency medical treatment. He clearly knew the process. He did not file a single one for his diabetes.
What were the other request forms filed about? Were these other ailments?
Yes, Your Honor. There'd be, I believe, sore throats. One was at least back issues. As Ms. Kennedy described, the one interaction that Dr. Moran had with Mr. Hickson, it was regarding his lower back issues, some back pain. And as she pointed out, Dr. Moran, asked him about his diabetes, and Hickson responded with, "I'm here about my back." And that is an uncontradicted testimony and evidence in front of district court, that the only time Dr. Moran saw Hickson, he raised his diabetes, and Hickson in response did not want to discuss it. And so the district court properly framed this case as a disagreement as to treatment. Dr. Moran, based on the variability of Hickson's sugar readings, prescribed a diabetic diet, which is treatment, and also ordered daily blood sugar testing. Now, Mr. Hickson obviously argues that his blood sugar kept rising and that Dr. Moran did nothing in response. But Dr. Moran did do something in response. He ordered the testing to be increased to twice a day, which makes sense. If he's concerned about the variability of the blood sugar readings and is concerned about the side effects of medication, including insulin, that may occur due to low blood sugar, that increasing the testing would address that issue. Now, of course, if Mr. Hickson had been incarcerated for longer, and if the twice-a-day testing continued and demonstrated a long pattern of high blood sugar that was unaddressed by Dr. Moran, that could give rise to a claim for deliberate indifference. However, what we have here is an inmate who's incarcerated for approximately 5 months, where Dr. Moran got to treat him, and it is undisputed that Dr. Moran treated him. Now, Hickson disagrees with the treatment and has an expert that more should have been done. But the standard here, as the court has pointed out multiple times, is deliberate indifference, which requires that Dr. Moran must not just be aware of the inference, but actually draw the inference. And here, there's absolutely no evidence that Dr. Moran drew that inference. And the reason for that, again, is simple, because he had no reason to. Hickson never complained of any symptoms to his nurses. In fact, in the district court's opinion, the objective prong was a close call. By the time we got to summary judgment, plaintiff's counsel conceded that there would be no long-term damages. Testimony.
Are there any injuries that flowed from this?
Well, so they essentially conceded the long-term, Your Honor, and relied on his deposition, on his testimony that he suffered several symptoms during incarceration. Even though he never complained of them to nurses, he testified as to, I believe, blurred vision, paresthesia, and general emotional distress due to his concerns about his blood sugar. And the district court found the objective prong, but that was a close call. And so, but the second prong is not a close call. And Judge, you obviously pointed out the battle of the experts, and it's clear if this was a negligence standard, then we would likely not be here, and we would likely have tried the case, and we'd probably be in front of this court after trial. But on a deliberate indifference standard, you have.
Well, as Judge Traxler's question pointed out, the plaintiff's own expert was talking about negligence, and in the oral argument earlier, appellant's counsel was, and I think it's candid, and the court appreciates the candid, but they were talking, there was a lot of discussion about reasonableness and everything. And when you look at the one expert testimony and you look at the argument, and they're both candid and straightforward, which I appreciate, but the whole thing sounds in negligence, if it even rises to that level.
Yes, Your Honor. And I would also point out that appellant in his opening brief faulted the district court on the gross negligence claim for not viewing it in the perspective of a reasonable jail physician, which, as you pointed out, Judge, Dr. Roop has never practiced in a jail, unlike Dr. Moran's expert. So that argument was a bit perplexing, but and I'm going to butcher her name, I apologize. Dr. Schwab testified as a doctor with experience in the correctional setting. And there are material differences in how some of these factors play in a correctional setting. There's a change in diet, a change in routine, in addition to the difference of the number of, obviously, patients and some familiarity with patients. But what this case is a case of negligence. Routinely throughout the case, there have been arguments based on reasonableness. But as this court has pointed out, that is not the standard. The standard is deliberate indifference. And what plaintiff must show is that Dr. Moran drew the inference and ignored it. Essentially, which, as the district court framed it, did not provide the treatment he knew was appropriate and required. That's why in the Cinto case, this court found deliberate indifference. And I apologize, Judge Wilkins, if you're trying to talk.
Well, in the Cinto case, there was something very different from here, because there was a refusal to give medical treatment for a non-medical reason, which was that the doctor reviewed the patient as insubordinate, and so he was rationing medical treatments for completely non-medical reasons, and you don't have any suggestion of that here.
Correct, Your Honor. Your Honor phrased it better than I would have, but that was a point I was going to make, that in that case, you had a prescription for specific medication that was then withheld by the doctor for non-medical reasons. Here, we have a disagreement as to what Hickson's treatment should have been, but we absolutely do not have any evidence that Dr. Moran failed to provide treatment or withheld treatment that he knew to be required. And in Cinto, there's also obviously the distinction that is a type 1 diabetic, whereas Mr. Hickson is a type 2 diabetic. Well,
let me ask you this, counsel. Do you have any, we've been over this, do you have any further questions or further comments that you wish to make? If you don't, I'm going to just turn it over to my colleagues and ask if they have some questions of you. Do you have anything further to say? Or?
No, Your Honor.
Well, then let me ask my colleagues if they have any further questions. Judge Rushing, do you have any questions here, Mr. Didak?
I don't. Thank you.
Judge Traxler?
I do not. Thank you for asking.
All right. Mr. Didak, we have no further questions. And so what we'd like to do at this time is hear from Ms. Catalina in rebuttal.
Sure. Thank you so much. I just wanted to address a couple of brief points. First, about the jurisdiction. It is true that the district court does say insulin or otherwise, that Mr. Hickson received no insulin or otherwise. But our predominant point, and the thing that we would really like to send home here, is that the district court does not provide any reason, in the face of Mr. Hickson's rising blood sugar levels and in the face of his rising A1C levels in specific, that no metformin would be administered to him. Moreover, it is true that Mr. Hickson made complaints about other issues. Our issue here is that Mr. Hickson is not a physician. He was asking for diabetes. A prisoner should not need to say some sort of magic words. If he's asking for treatment and the risk is sufficiently obvious, that meets the standard for deliberate indifference. And furthermore—
Well, let me just say this on the jurisdictional point, that often district court opinions respond to issues that are raised and that are emphasized in the non-moving party's brief. And in this case, as I read the petition, that Hickson was really complaining about insulin. And so the district court emphasized a point that was in the non-moving party's brief. It was a responsive opinion. And that's a hard thing to criticize because we do it up here. We look a lot of times at the brief, and we can discern from the emphasis that the brief puts on something, you know, what the appellant really wants to put his chips on, and what other claims are simply throwaways. And we try to respond to that. Sometimes we include the kind of footnote that my friend Judge Traxler suggests, and I think it's a good thing to do. Other times we may not. But it's hard for me to criticize the district court for following the train of the deposition, because that's what I do sometimes, is just follow the train of the brief. I said, okay, this is the issue that the appellant is really serious about, and we'll spend our time addressing it.
Sure, and Your Honor, our aim here is not to criticize the district court. Our aim here is just to make sure that all of the triable facts have actual, that all of the live claims at the district court level have been addressed and in their entirety. And if there had been a little footnote that said, we've considered for the claim for metformin and we disregard it, I would be making a different argument here today. But the issue is that no such comment had been made, and it's just not clear whether the district court—
That may be a better practice. The question is whether there's a difference between— there's got to be a difference between better practice and reversible error. And they've got to be, you know, what do we do? Send it back for him to include that footnote? I mean, it doesn't, that as a practical matter, I'm not sure that makes sense. Although I agree, it's certainly better practice, but I just think there's a difference between better practice and reversible error. That's my problem.
Sure, and I'm not sure we're describing this as that in particular as reversible error. We're simply saying that it should be remanded because it isn't resolved. We don't, sorry, go ahead. Oh,
all right. All right, Ms. Catalina. If my colleagues have any further questions, be delighted to hear them, but otherwise, I want to thank you very much for your argument, and we appreciate the points that you've made.
Thank you so much, Your Honor.
All right, counsel, we can proceed right into our next case.
Thank you, Your Honor, and may it please the court. My name is, and I represent the relator in this case, and by extension, the taxpayers of North Carolina. The defendants in this case are a group of adult care homes, and they billed Medicaid about 12 hours for each 8-hour shift that their employees worked. That's shocking on its face, and the question here is simply whether that's allowed under the law. Now, maybe that was allowed before 2013, when providers could and did bill per diem, but the policy was changed in 2013 explicitly to prohibit exactly that type of per diem billing, and instead to require billing by time for time actually worked. But the defendants here simply ignored that change, and they kept doing what they had been doing. They put their head in the sand because they wanted to keep billing the maximum while working the minimum. By doing so, they violated the False Claims Act, and they should be required to repay what they overbilled. The plaintiff's first claim here is a simple one, that defendants submitted false bills to Medicaid because they claimed that they provided certain numbers of hours of care, when in fact they did not provide those hours of care. And the main policy at issue here, as we outlined in the brief, is Policy 3L. The plain text of Policy 3L controls in this case. It clearly requires that defendants and everyone else bill by units of time, 15-minute increments, for time actually worked. And that plain text is buttressed by other parts of the plain text of Policy 3L. For example, the 7/8 rule, that is all about minutes. Second, the entire purpose of Policy 3L is maximum number of hours. All these beneficiaries...
Well, the 7/8 rule isn't a strict time rule, because you can round something off to 15 even if you only spend 8 minutes doing it.
That's right, Your Honor, and that's the purpose of the rule. But the existence of that rule shows that you have to bill by time for time worked. If you could bill per diem as defendants here, there's no purpose at all to the 7/8 rule. But there's also the entire purpose of Policy.
I don't think they're saying bill per diem here. I think they're saying bill on a completed task basis.
Well, Your Honor, so number one, it's impossible to bill by completed task basis because there is no time allotted to tasks. And there just isn't. It's impossible to do that. And frankly, the defendants in their brief admit that it's impossible to do that. So I think...
Well, I thought that one of the arguments they were making here was that completed task was a proxy for time, in the sense that a certain number of authorized hours were assigned to each task.
So, Your Honor, I want to be very clear. There were no number of authorized hours for every task. It is impossible to add up, X, Y minutes for this and Y minutes for that to get to a number. It's impossible to do that. Now, Your Honor, I think the confusion about that is not the fault of the court at all, because the defendants made that argument below, and I think it confused the district court as well, because the district court...
Well, why aren't the task a proxy for the time spent? I mean, in this sense that you can't complete a task without spending time on the task. And so I wonder here whether there's the strict dichotomy about the completed task basis and the time devoted basis, because, as I say, if you complete a task, you have to spend some time completing the task. The task doesn't complete by itself. I wish it did, because then I could take off many a weekend and I could come back to my desk on Monday morning and find that the work was somehow done. And I just wonder whether there's this stark dichotomy that you're positing.
Well, Your Honor, two responses. One is that the beneficiaries receive only one total number of authorized hours. It's a maximum number, an up to number. It cannot be broken out by tasks in any way. And so if a beneficiary comes to the defendant, let's just say John, and John has 120 authorized hours, that's the only number. It's a single number. It's not broken out. And so what the defendants do is always, always, always bill the 120. And that's why it's per diem billing. They never look at the tasks. In fact, the billing people don't even know about the tasks. They have no idea what tasks are actually performed. And so they're billing here the same way that they were billing before the policy was enacted. And so the only way that defendants, I gave them sort of credit for their theory in the brief, is that, well, if we always perform all of the tasks all the time and never miss a single one, then even though we don't, we don't track time, and even though we per diem billing, well, per diem billing would be okay because we always do all the tasks.
Well, wouldn't it just, again, isn't the completed task what's of most interest to the residents of a senior center? I mean, if a resident is having difficulty dressing or bathing or toileting or whatever, what would you rather have? Someone who completes the task and helps a resident feel fresh and all the rest, or someone who spends time but doesn't have anything to show for the time? In other words, I'm wondering whether the completed task metric isn't more, or could be seen as more, providing more of a real life benefit to the actual residents of this center, because I've seen a lot of people who are working by the clock and they're just sitting there. And then there are other people who may spend less time in an office and get a whole lot more done. And so I'm just wondering, from the standpoint of the ultimate beneficiaries of this North Carolina Medicaid, well, a task completed metric, it makes a certain amount of sense, wouldn't you think?
So, Your Honor, putting aside what Policy 3L actually allows, I understand Your Honor's concern, what's best for the beneficiaries. I think it's clear that what's best for the beneficiaries is not what's happening here. So yes, it's important that the tasks be completed. Obviously, we want tasks to be completed and people to be cared for. However, there are separate audits about that issue. Whether the tasks are completed is sort of a separate issue from how the defendants here bill for that. Now, by the way, because of how they bill, they are not doing all the tasks. And we noted that.
But that's a different issue. And one of the questions I have is, when you're talking about a fraud case, and that's what we're talking about here, where is the deception? You might not like the billing method, but normally you have to have some sort of knowing deception, which is calculated to induce reliance. And was there deception here? Did they fail to disclose their books, or what?
So yes, there was deception here. Under the FCA, the two things I think Your Honor is talking about are materiality and scienter, which are a little bit different. For example, scienter, you do not need to show that you absolutely knew what you're doing was wrong. Deliberate indifference, sticking your head in the sand, that's enough. So let me address that very briefly, because I think that's both of those are clear. Materiality, first, there's the objective standard. The defendants don't even mention that in their brief. That's purely objective. And I suggest that under Policy 3L, it's completely unreasonable for the defendants to think that they don't have to bill by time that they can always bill the maximum, even though.
Oh, but all right, but I think you're not answering my question, because what I wanted to know is that these books are monitored by the North Carolina DHHS, the Health and Human Services Department of North Carolina, and in the depositions that were taken by the North Carolina officials, I didn't see any indication that they thought that there was deception or whatever. It all seemed to relate to the method of billing. The method of billing is a different question from whether there is deception, and deception is a normal element of fraud. And were they hiding the books from the auditors? And if so, why didn't the auditors say that in the course of the extensive discovery?
So there was deception because the auditors never looked at what mattered here. The only thing the audits looked at is they went to the
Did the auditors think there was any kind of deception?
No, because the audits didn't look at what matters here. The auditors only look at the task logs. They want to know, hey, are all the tasks checked off as completed?
Well, but the auditors have a pretty intimate acquaintance with how this billing system works, and there was lengthy discovery, and on both sides, and I just don't. I don't see I just don't see the kind of concrete evidence in the summary judgment record of deception.
Well, so again, the auditors never looked at what was going on here. Nobody knew that they were billing every single hour, no matter what, even though they were staffed to the absolute minimum. Nobody knew until this case. Mr.
Sigmund, let me ask you about that. They talk about a 2016 audit during which they were asked for, the care homes were asked for records related to their time and the time that they were tracking. And Mr. Stahlschmidt was confused by that because they didn't keep track of the time, and reached out to North Carolina Medicaid and said, basically, what does this mean? We're not required to keep track of time. We don't do it. And someone from North Carolina Medicaid told him, basically, don't worry. Someone will get back to you if there's a documentation problem. And they didn't hear anything. Now, that doesn't tell them one way or the other what they should or shouldn't be doing with their bills, but it does indicate some lack of scienter, to Judge Wilkinson's question, some sense that, nothing's being hidden here. People may be confused and they might be doing it wrong. But where is your sort of contrary evidence that, in fact, there was deception and an attempt to sort of hide what's going on?
So first off, Mr. Stahlschmidt admitted that when Policy 3.0 was first rolled out, he just did not understand how that actually applied to adult care homes. He admitted he didn't understand it, but he didn't go and ask for clarification. Instead, he talked to a friend of his and they just decided, hey, this just must not apply to adult care homes. I think that's classic sticking your head in the sand. If you don't understand something like that, this is hundreds of millions of dollars a year defendants billing the state. I think you should be required to at least ask for clarification. And it's important to note that the standard for scienter, of course, is very low on summary judgment. The Skybo case that the defendants cite notes that it's very, very rarely appropriate to grant summary judgment.
Well, no, the Supreme Court has actually indicated that summary judgment is a very appropriate tool in these key TAM cases. I mean, I think they've said that.
I agree about materiality. The court has said that it can be, but specifically on scienter, which is the question asked now, this court in the Skybo case recognized that scienter, of course, is the state of mind. It's hard to prove. It's usually proved by circumstantial evidence.
But we resolved it there and in Complin. And Complin, I think, is very similar because you had a disputed interpretation about how someone should interpret a regulation. And in your brief, you say that your scienter argument is based on how plain the regulation is. Do you have anything else that demonstrates the required state of mind other than how clear you think the regulation is?
Well, again, Mr. Stahlschmidt admitting that when Policy 3.0 was rolled out, he didn't understand how it applied, and he stuck his head in the sand. Furthermore, the billing people here are totally separate from the people who know about tasks, and so there's no connection. The defendants have no connection between the billing folks and the task.
Well, but what other cases are there, to follow on Judge Rushing's question, what other cases are there where a key town suit has been allowed to go forward, where there's been no deception, and where there's been auditing and the auditors have raised no question? I mean, I always thought that with cases like Iqbal and Twombly, that the Supreme Court on cases, this is a little bit different because it was dealing with securities fraud, but I thought that the scienter element in some of these fraud cases, and this is a genus it's a species of fraud, I thought the Supreme Court was requiring at the motion to dismiss stage plausibility, and I don't see why that wouldn't carry through to the summary stage as well. And there are all kinds of indications, shall I say, that fraud claims just shouldn't be allowed to go forward on accusation, and one is what we've just pointed to in Iqbal and Twombly, and you see the same thing, a reinforcement of that in the Federal Rule 9 of Civil Procedure, where I think that the fraud claims are supposed to be proven by clear and convincing evidence. And in the face of all this, if we say, oh no, there's no problem here, this fraud claim can go forward simply because of a dispute over the interpretation of a regulation, that's where the auditors were not raising questions, were actually making the payments. But if we say that any sort of dispute over regulations, and my Lord, the Code of Federal Regulations has, I don't know how many regulations about which there could be a dispute of interpretation. And we're just off to the races if we say that scienter is proven whenever people have, when there's no deception, but people have a simply different view of a regulatory scheme. I just think opening that door is very difficult. Wouldn't you agree?
Yes, I see that my time has expired.
No, you wouldn't agree, but tell me why not.
I'll just very briefly, Your Honor, since my time has expired, but I want to answer the question. So, number one, I think the text here is plain as day, and so there's not a reasonable dispute about what it means. But going to scienter, again, the FCA was amended specifically to disallow sticking your head in the sand. And so even if the defendants were confused about what Policy 3.0 meant, which they claim, you can't just say, you know what, I'm not going to ask. I'm not going to figure it out. Because there could have been just one document in this case, just one that allowed them doing what they did. Just one document saying you can bill per diem or always bill the maximum number of authorized hours. I mean, it would have been so simple. You would think out of an 8,000-page joint appendix, there would be one document.
Isn't that how the template works? Isn't that how the billing template from the state works? It takes the authorized hours and it distributes them over the week or over the month. Can you refresh my recollection on what the record was on that?
With respect, Your Honor, I'm not sure exactly what document you're talking about. There is the chart that's attached to the Policy 3.0 that lists the minutes that are used in a way that nobody knows to add up to the total number of authorized hours. But there is no document that I mean, there's, and then, the defendants create a plan of care that says we're going to do these tasks on these days. But notably, that plan of care does not have any minutes attached to each task or each day, because you can't do that. And so the plan of care has one number at the very top. It says 130 hours, and that's it, because you can't break it down. Real quickly, Your Honor asked for a case about scienter. We cited the Kryzik case from the DC Circuit 97, where a doctor failed to review his bills, and the court noted that if he had reviewed them, it would have shown claims for excessive hours. Sometimes.
Counsel, can I shift for just a minute from scienter to materiality? And I'm just not sure how we would work around the Supreme Court's Escobar case, and particularly this paragraph. It says, conversely, if the government pays a particular claim in full, despite its actual knowledge that certain requirements were violated, that is very strong evidence that those requirements are not material. Or if the government regularly pays a particular type of claim in full, despite actual knowledge that certain requirements were violated, and it signaled no change in position, that is strong evidence requirements are not material. And then, as I understand the record here, and if you look at JA 66119, it is continuing to pay the claims submitted by the defendants. Now, given that, and how do we work around that?
So, Your Honor, first off, the government here did not know what was happening until this case was filed. The audits do not look at what matters. So the government was not paying here with full knowledge of what was happening. So that information, what was going on. Now, as far as DHHS continuing to pay as this lawsuit is going on, many cases have held that that's not surprising at all. That could be because of bureaucratic indifference or neglect. The state here is changing its plan, so maybe it just doesn't care because there's no prospective effect. Plus,
I find that hard to believe that you think the government didn't know what was going on here. It's auditing the books. It's the one that's paying the bills. To sort of say, well, the government had no idea, then that might be a suit against the government. But, well, that runs into different difficulties. But I'm not sure. To say that the government had no idea what was going on here, the government knew that the past practice in this instance was on a completed task basis, and after this amendment was put into effect, but given that the completed task was the basis for the bills prior to the change, and there was no particularly different method of billing after the change, and you say, well, the government had no idea about any of this. I can't believe it. They were continuing to do what they'd always done. And if the government had it strikes me as odd to claim, well, the government had no idea, when the government seemed to be, well, we're going to string these folks up when the regulation is confusing, and when auditors have not found any non-compliance. I mean, there are companies all over the country and contractors all over the country that have tried to deal with the government in good faith, but they are at a disadvantage with this morass of confusing regulations, and it sometimes it drives a statute. So we're not just talking about ordinary damages here. We're talking about some huge sum. And a treble damages statute, as I understand it, that the more conservative estimate of the defendant's overpayment, or the overpayment over 5 years, would be something like $43 million. And then, because it's trebled, you would put them on the hook for $130 million, relatives' attorney's fees, and all reasonable expenses incurred by the relative in bringing the litigation and everything. And I don't see how the defendant can survive on something with it's not all that profitable a business. Some of them work on a very, very thin margin. I understand the states wanting to cut down on the amount that they're spending on Medicare and Medicaid. Medicaid is a huge chunk of the state legislature's budget, and I understand that. But I also understand the other side of the argument, which is that, you know, the medical profession, from doctors to hospitals are, you know, they complain loudly and regularly about the rates of reimbursement. So I'm sympathetic to both sides here, but what I worry about is going into waters that are deeper than we realize. And if I'm talking about $130 million judgment being awarded to the against the defendants, plus attorney's fees and expenses and everything like that, isn't that a pretty heavy hit? I mean, that just could be it for this facility. And, you know, maybe they're doing a good job, but maybe they're not. But, you know, if they are doing a good job, you know, how does a hit like that advance public health in North Carolina? That's what I'm wondering. We're talking about, when you treble it, you're talking about huge sums. Do you see my concern here?
Very briefly, Your Honor, yes, I certainly see your concern. There's no evidence in the record about how much money these defendants have. They are together the largest provider in the state. It's not in the record, but I can assure you it's a very profitable business, and these guys make a lot of money. If Your Honor's concern is about the quality of care in North Carolina, if it's about what old people and people with problems, how they're being affected and to make sure they're the best care, if that's the court's real concern, I urge the court to read the facts section of our brief closely, read the briefs closely, because I very strenuously believe that if care is what matters, that the plaintiff here, the relator here, we're the ones that are trying to vindicate the interest of the
Well, I mean, I think quality of care is a different suit, but you know, there was a judge from South Carolina who was a very fine judge, and his name was Bob Chapman. And when I first got on the court, he said, you know, one thing you need to remember is do no harm. Just don't make things a whole lot worse. And I just worry about what you're asking us to get into. We don't know how to devise a time-based system, or what that would add to red tape or whatever. I mean, I just wonder whether this is outside of our bailiwick. But I'm worried that we could inadvertently do a good deal of harm. That's my problem. And it's not that I'm not sympathetic to what you're saying, because as a state legislature, I'd be very concerned about the percentage of the state budget that was consumed by these galloping health care costs. But the other folks of it, you know, they've got a point too. And aren't we at risk of doing some unintentional damage? I mean, we could be walking into an ambush. This is my problem, and I want to. I'm sorry for the length of the question, but but the length of it is because of the depth of my concern. And so I'd like to give you a chance to respond to that, Mr. Sigmund, if you would.
Sure. My main response is that North Carolina's system is being transitioned right now to the managed care model, and totally different. This entire way of billing, paying is totally different, literally right now. And so this case will have no prospective effect at all. The only effect this case will have, the only effect is a retroactive for money damages to whatever extent we can prove them at trial. That's it. And so I understand the court's reluctance. This court is not a policy-making body. It doesn't want to get into the weeds and start, interfering with complex state agency determinations. I get that. I don't want to do that either. I'm a lawyer, and I don't want to do that. But I believe, with all due respect, that this case is asking this court to do something that's directly in its bailiwick. Apply the False Claims Act as Congress enacted it, with the intent behind Congress enacted it, about scienter and everything else, and to stop false bills, or not stop them, but to remedy false bills in the past. And so I think it's clearly in the court's square jurisdiction. Thank you.
All right, I want to ask, don't go away, because my colleagues may have some questions for you. Judge Traxler, do you have some questions?
No, thank you. I have no questions.
Judge Rushing?
I don't, thank you.
All right, Mr. Phillips, then we'd be happy to hear from you.
Thank you, Your Honor. May it please the court. My name is Jim Phillips with the law firm of Brooks, Pierce, McClendon, Humphrey, and Leonard in Greensboro, North Carolina. I'm here along with Jennifer Van Zant, DJ O'Brien, and Kim Marston on behalf of the appellees. Your Honor, I'd like to focus my argument today on the scienter and materiality elements of the False Claims Act. We believe, in particular, that Relator has failed to come forward and meet the standard required for evidence of those at this stage of the case. The first thing I'd like to do is to address Relator's counsel's statement that suggested that Mr. Stahlschmidt stuck his head in the sand, that Mr. Stahlschmidt testified that he didn't understand the billing requirements of Policy 3L. Relator says that in both of his briefs and cites there to the joint appendix at pages 2073 to 75, where Mr. Stahlschmidt says no such thing. What he said is that he didn't understand why the 7/8 rule was in Policy 3L. And that makes sense from the adult care home perspective, because all of the North Carolina Medicaid witnesses who testified explicitly that the 7/8 rule didn't apply in adult care homes. So that's not what Mr. Stahlschmidt testified to. Relator says in both his opening and reply briefs that there is plenty of evidence of scienter, but then he offers none. He offers as his only proof the contention that Policy 3L is so clear on its face that a provider may bill only for the time actually spent, that the defendants had to know that was what was required. That harkens back to this court's decision in Complin, and we do believe that Complin and Skibo are on direct point here. In Complin, the district court summarized Relator's allegations of scienter, and that summary reflects the extent of Relator's evidence here. To quote, Relator asked the court to infer scienter from the alleged regulatory violation itself, because the hospitals were sophisticated entities presumed to know the law, Relator argued. Their failure to comply could only have been knowing. That was insufficient there. It is insufficient here. Policy 3L says nowhere what Relator says it says. Its only reference to billing is in the appendix, where it directs providers to bill in 15-minute units, but it says nothing about what providers may or may not bill for. Overlaid on that language, or lack of language, in Policy 3L is the guidance that North Carolina Medicaid provided to defendants from the time the policy was adopted until today. Guidance that providers in adult care homes don't have to track the time spent providing PCS. That if defendants provided the PCS called for on a residence service plan on a particular day, they could bill the time on that plan for that day. That even if defendants didn't accomplish all of the subtasks associated with a particular ADL, As long as they accomplish one, they could bill for the whole ADL. And the fact that such guidance was given was not only confirmed by the North Carolina Medicaid witnesses, it was reiterated by them in their deposition testimony as their current interpretation of the policy. And as this court has acknowledged, following government instructions cannot be a false claim. But even if you ignore the guidance to defendants from North Carolina Medicaid regarding what you could bill for, the testimony of those same witnesses regarding what Policy 3L says and doesn't say, specifically the lack of clarity on billing and reimbursement, would compel affirmance based on the Siena element. First, it's undisputed that all of the rules related to North Carolina Medicaid's PCS program are in Policy 3L, nowhere else. And testifying about billing and reimbursement, those North Carolina Medicaid witnesses said on the record that Policy 3L doesn't speak specifically to time and indicate whether providers should bill based on specific time. The policy, they said, is, I quote, silent on that. They said Policy 3L doesn't speak to billing practices, that it doesn't prescribe billing practices. And each one of them said that the 7/8 rule doesn't apply in adult care homes. At best for Relator, this establishes that Policy 3L is ambiguous as to whether defendants could bill only for time spent providing PCS. And as this court recognized in Compline, even the loosest standard of knowledge is difficult to prove when falsity turns on a disputed interpretive question. This case does not present the hypothetical situation the court discussed in Compline, where a defendant might be warned away from an interpretation. Here, the defendants were guided into their interpretation that if they delivered the PCS on a service plan, they could bill the units for that day. And the affidavits of Mr. Campbell at 6099 of the Joint Appendix and Mr. O'Neill at 6121 confirm that the assisted living industry as a whole interpreted Policy 3L this way, based on North Carolina Medicaid guidance. And as this court explained in Skibo, an industry-wide understanding such as this negates the notion of Siena. Perhaps the strongest evidence that defendants lack Siena is in the affidavit of Tom Stahlschmidt. And I won't go through that again because Judge Rushing laid it out piece by piece. Members of the court, that's not how you act if you're trying to hide fraudulent billing practices. Turning to materiality. The U.S. Supreme Court said in Escobar that the materiality standard in a False Claims Act case is demanding. Relator must show that the alleged false statement was material to the government's decision to pay the defendant's claim. The evidence in this case establishes that the amount of time spent providing PCS was not material to North Carolina Medicaid's decision. Ms. McFadden, who runs the program, said it best and plainly at 6394 of the Joint Appendix. I asked her, tell me whether or not this is true, that the amount of time spent providing PCS by a provider doesn't matter to the billing as long as the tasks associated with the ADL were performed. She answered, based on our discussion, if the task was performed, they could bill for the time, for the service. No matter how much time was spent, yes. And that bill would be paid by North Carolina Medicaid? Yes. Further proof of the lack of materiality is that defendants' audits did not check to see the amount of time spent, only whether the tasks were performed on particular days. Finally, with regard to materiality, it's been 4.5 years since the government saw the complaint in this case. Defendants are still billing the same way they did and on the same basis that they were then. They're staffing at the same levels. The government is still paying. The Assistant Director for Investigations, Patrick Pickett, for the Office of Program Integrity of North Carolina Medicaid testified that his office has not undertaken to investigate or audit these issues. Policy 3L hasn't been amended to change anything relevant here. If this mattered to the government's decision to pay, that would not be the case. Members of the court, if you have questions, I'm happy to answer them.
All right, my colleagues have questions. We'd be happy to address those to Mr. Phillips.
This is Judge Traxler. I have a question. Mr. Phillips, is it your position that the method of billing used by your client was in conformity with regulation, or was not in conformity, but you did the best you could based on the information you were given by Medicaid authorities?
Both, Your Honor. We believe that we billed consistently with the way that Medicaid told us, and therefore there is no falsity. And Judge Rushing asked a question that goes to this. She referenced the fact that North Carolina Medicaid told providers to break down the total hours in a month. And that comes from the joint appendix at page 5487. It's actually in the record a number of times, but this is 5487 is a billing seminar that was put on by North Carolina Medicaid.
Mr. Phillips, I appreciate all that, but really my question was, I think, a lot simpler. Your position is that the way you did it was right. And is it also your position, a fallback position, that even if it was wrong, there's no scienter?
Yes, sir. That's exactly our position.
Okay, I just want to make sure I understood. Thank you, Judge Wilkinson.
Do you have any further questions, Judge?
No, not me.
Judge Rushing?
I don't either. Thank you.
All right. Thank you, Mr. Phillips. We'd like to hear from Mr. Sigmund now in rebuttal.
Thank you, Your Honor, and may it please the court. I welcome any questions if the court has any further ones. I covered 30 minutes on the first half, so we covered a lot of ground. In response to Mr. Phillips, just a couple points. You know, he mentioned the testimony of Ms. Lee. You know, what's interesting is that he didn't mention the testimony of Ms. McFadden. Ms. McFadden was shown exactly how the defendants billed in this case, exactly how, and she said, quote, "I would not agree that that was the correct thing to do." Furthermore, defendants counsel consistently, multiple times, tried to get Ms. McFadden to agree with this proposition, quote, "The amount of PCS hours that a provider can bill for a day has no relationship to the amount of time providing PCS on that day." They tried to get her to agree with that proposition because it perfectly describes how they billed, and she consistently refused to agree with that. Ms. McFadden also testified, quote, "There's not a daily entitlement to reimbursement." And again, it's important to note the entire purpose behind Policy 3L is a maximum number of hours. It's authorizing a maximum number, but the defendants don't treat it as a maximum, they treat it as an entitlement. And the entire purpose of Policy 3L is reimbursing.
That actually reminds me of a question I had for you. In your brief, you refer to this as a maximum number when you're talking about the false and fraudulent bills. But I was a little confused when you talk about implied certification. I think you turn to talking about this number as this number is what is required to give the patient care, to give the beneficiary the care they need, and anything less than that number of hours is deficient care, which seems to not treat the number as a maximum. And I wanted to give you an opportunity to clarify that.
Well, right. So for the implicit claim, the beneficiaries are given a certain number of hours, let's say 120 hours. That would be an up to maximum. And so, of course, they need that amount of care, but that's the maximum amount that can be billed. And so the defendant, if someone's authorized for 120, the defendant should be giving them 120, and then they should bill 120, and they need 120. The problem is, though, if defendants don't provide 120, if they provide only 80, then they should bill 80. And so, I mean, the answer is the authorized hours is what they need. That is a true statement. But but it still is a maximum number, meaning you should bill up to that maximum. Now, hopefully you provide all that care, but if you don't provide it, then you're billing more than the maximum, or you're treating the maximum, you're treating it not as a maximum, but as a set entitlement. I also, very briefly, Mr. Phillips mentioned billing by tasks. Again, that's just impossible to do. And finally, I do want to just reiterate the point about the fact that DHHS has not intervened here. Many cases have recognized that that's not controlling here. It's not, to some degree, it's not particularly important. The Prather case in the Sixth Circuit, for example, noted that the government's lack of intervention in a case or changing anything about what they do after a case has been filed would undermine the very purposes of the FCA, of the False Claims Act. If you always needed the government to take some sort of action, then you wouldn't need private plaintiffs like the plaintiff here to do what they're going to do. Second, one reason DHHS may not have intervened is because they might think that they have great lawyers right now doing all the work. Why would they intervene? I mean, we're having an oral argument right now where all these issues are on the table. Finally, Mr. Phillips, in his brief, always talks about guidance from DHHS. I just want to be clear: there is no guidance here that says that they can do what they do. Not one document. There could have been one document that said, "Hey, you can bill per diem, or you can bill the set amount of hours per month per beneficiary," but that just does not exist. And finally, again, the entire, and this goes to Santer too, the entire purpose of Policy 3L was to change how people were being billed. In fact, some people at DHHS did not like that change. There was testimony. We deposed them, and they said, "I didn't like that. I did not like going from the per diem to this time-based billing. I didn't think it made sense." But you know what? That's what happened. And so that goes to materiality of DHHS, but it also goes to Scienter. Everyone in this industry understands.
Interrupt you just a sec. This is Judge Traxler. Can you tell me where that is in the record? The statements you just made about everybody in the industry recognizing the change and many objecting to it?
Yes, Your Honor. If you give me 1 second, I apologize for not having that on my Joint Appendix 1528 to 31. Yeah, 1528 to 31.
Thank you.
If Your Honor, if anyone has any questions, I welcome them. Otherwise, I appreciate your time. Thank you.
We thank you, Mr. Sigmund. Any further questions from anyone?
Not me.
All right, we will take a 5-minute recess and then start into our final case.
This honorable court will take a brief recess.
I'll move the attorneys into the waiting room.
are the judges all present?
I'm here.
All right, Judge Rushing?
I'm here also.
Excuse me, Judge Rushing, are you here?
Yes, sir.
Okay, great. We're ready to go, Sarah.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
All right, we'd be happy to hear argument in American Federation of Government Employees versus the Office of Special Counsel. And Mr. Burke, is it?
Lyons Burke, Your Honor.
All right. Whenever you're ready, we'd be happy to hear from you.
Yes, Your Honor. May it please the court, my name is Kyle Lyons Burke, and I represent the appellants. The district court's dismissal of this case for lack of rightness should be reversed because the court relied on the DC Circuit's opinion in O'Connor, which is flatly inconsistent with this court's precedents in both Cooksey and in Kenny. In Cooksey, this court explained that for First Amendment pre-enforcement challenges, courts must look at ripeness and standing through the same lens. And in Kenny, this court explained that a plaintiff can demonstrate that a pre-enforcement First Amendment challenge is justiciable in two ways. First, if a plaintiff has an intention to engage in conduct that is prescribed by a statute and there exists a credible threat of prosecution. And second, if there is a sufficient showing of self-censorship, which occurs when a claimant is chilled from exercising his right to free expression. Plaintiffs here meet both tests. First, plaintiffs submitted affidavits indicating that two of their members wished to engage in speech that was prescribed by the government's policy, both on the issue of impeachment and on the issue of the term resist. And as this court has noted, there is a presumption when there is a non-moribund statute that facially restricts expressive activity, it presents a credible threat of prosecution. Such a threat exists here.
What speech are we talking about here?
Your Honor, this would be discussion of the impeachment of former President Trump and use of the term resist while in the workplace.
Have they engaged in the speech?
No, Your Honor, they have not. Both of our employees submitted affidavits saying that they wished to engage in the speech and they thought it was an important issue, and yet they did not out of fear that they would be prosecuted by the Office of Special Counsel.
Well, it seems to me that the speech, it seems to me that the speech that they wish to engage in would be permitted.
Your Honor,
at least under the revised OSC guideline.
Your Honor, there is certainly an open question there. With respect to impeachment, the Office of Special Counsel's guidance said that discussing impeachment would be permitted and expressing an opinion on whether or not President Trump should have been impeached was permissible.
So what do I don't understand. What are we talking about here if discussion of impeachment and resistance would be permitted?
Well, Your Honor, for impeachment, the policy also said that advocating for impeachment would not be permitted. And plaintiffs' members are entirely unclear on whether speech crosses the line from discussing impeachment to advocacy. Our employees are not sure whether they can say President Trump should be impeached, if that would be permissible. If it is important for the country that President Trump is impeached, would be permissible. It is very unclear when these types of expression, the speech, would cross the line in OSC's opinion from an opinion on whether he should be impeached to advocacy. And one of our issues here is that the vagueness of the policy means that employees are likely to refrain from speech rather than risk violating the policy and risk potential termination from the federal government. Well,
but wasn't that basically a congressional judgment that was made in the Hatch Act, and Congress gave OSC the authority to implement it, or at least in the initial stage to provide guidance. And So we're talking about basically a federal statute and a scheme that's been set up here. And these OSC advisory opinions, we have an advisory body in the federal judiciary, the Code of Conduct Committee, and they issue advisory opinions all the time, and a lot of them are not perfectly clear. But if all that's going to give rise to a First Amendment suit or some kind of suit, that's quite a lot of litigation, isn't it?
Your Honor, I have two brief points in response to that. The first would be that one distinction here between the Code of Conduct arm for the federal courts and the Office of Special Counsel here is that the Office of Special Counsel are the prosecutors for any proposed violations. So this would be more akin to DOJ claiming that a certain conduct would violate a statute and subject a citizen to prosecution. For example, in cases of access to abortion clinics, if DOJ issued a policy statement saying that any protesters that were within 5 miles of an abortion clinic.
Well, the prosecution for something like that would be very, very rare.
Yes, Your Honor, but as this court has said, there is a presumption that a non-moribund statute that restricts expressive activity presents a credible threat. And Counsel, Your Honor, my second response.
Counsel, this is Judge Rushing.
Well, excuse me, Judge Rushing had a question.
I don't mean to cut you off, but I just want to clarify so we're all talking about the same thing. This policy, this guidance is no longer in force, right? So yes. you have an argument about, maybe they could still prosecute for past conduct. But when you're talking about your clients currently don't know what they're allowed to say, that's no longer the case, right? Because now they can say whatever they want.
That is correct, Your Honor. In that context, I was referring to when the policy was in force. And
but for when we're talking about ripeness, we need to be talking about what's currently in place, what's currently in front of this court is the policies no longer in effect.
Your Honor, I believe this ties a bit into the government's argument on mootness. And the governing standard there is because OSC voluntarily changed the policy.
Well,
I know, but are we at the point now of being asked to write an advisory opinion upon an advisory opinion? I mean, is this one advisory opinion on top of another advisory opinion?
Your
Honor, the first one being the OSC opinion and the second one being ours.
Your Honor, the only opinion that we are asking this court to issue today is that plaintiffs' claims were ripe. Any discussion of the merits of their arguments against the policy when it was in force and a potential future injunction against reinstituting the policy would be best served by the district court.
What is the chill now?
Your Honor, there is no current chill. However, because OSC voluntarily removed the policy and got rid of it, this case still presents a live controversy because of the self-censorship.
That affects your ripeness, right? There's no chill, there's no impact going forward. That's not just a question of mootness, that affects the ripeness of your case.
Your Honor, we would contend that the ripeness was established at the time the case was filed. And unless there is something changing.
But mootness circles back into ripeness on some occasions. I mean, as a matter of fact, quite frequently, sometimes you think of mootness and ripeness as separate concepts, but they're interrelated.
Yes, Your Honor, we completely agree.
Because if a case is moot to the degree that this one is, then it probably is unripe until a concrete controversy comes along. I'm just bothered by the lack of concreteness. I don't understand exactly what they said. I don't think they said anything. It seems to me what they were going to say was probably permitted, and I'm just concerned about gumming up the system that Congress has set up. And one thing that strikes me about the system is that it seems to contemplate initially OSC issuing an opinion, and the opinions are actually supposed to facilitate First Amendment expression and not to quash it. The whole purpose of these opinions was to provide a safe harbor and to let employees know, look, it's fine to do this. And, if we start litigating all this stuff, then OSC in the Hatch Act contest and all kinds of, the federal government works a lot of times with just this advisory opinion, and it serves a useful purpose because it gives employees notification of what they can and can't do. And it's very comforting sometimes to know that you can't do something rather than having to guess and guess. So if we litigate if every advisory opinion and said, oh, your language is somewhat less than precise and everything, there are going to be fewer of these advisory opinions issued, and a very useful tool is going to be compromised, and people are going to, without the advisory opinion, people are going to be guessing at a lot more than they're guessing at now, which seems to pretty clearly, the opinion now seems pretty clearly to authorize the speech you want to make, and more power to you. I'm glad it does. But the other question here is, in addition to the concern about compromising what is a very practical and useful purpose throughout the federal government, these things go, as I understand it, from OSC, and then OSC receives a complaint, and maybe it investigates. Most of the times it ends with action. Sometimes there's a warning letter. Very occasionally, rarely, there's a prosecution before the Merit Systems Protection Board. And then the Merit Systems Protection Board issues an ultimate opinion on whether the Hatch Act was violated. And then if you don't like that, you can go over to the Federal Circuit. But Congress has set up a fairly detailed and reticulated step-by-step scheme for resolving Hatch Act controversies. As I say, it goes from OSC to MSPB and then to the Federal Circuit, which resolves these cases all the time, and the MSPB resolves these cases all the time. And I don't see what business we have in sort of jumping into that. And I start reading this stuff and saying, I feel like I've been asked to crash the party. Congress has set up a scheme. It doesn't include us, and we're going to go barreling in. I don't get it. Law is confusing enough as it is without having too many chefs in the kitchen. And it seems to me that the designated chefs have been OSC, MSPB, and the Federal Circuit. So why should we mess around with the legislative scheme?
Your Honor, I would like to respond to that in 2 points. First, discussing your question about the beneficial nature of the advisory opinions, and second, about the scheme set up by Congress. With respect to the beneficial nature of the advisory opinions, I think Judge Mivka, in dissent in the DC Circuit's case in O'Connor, makes our point, which is that the special counsel cannot reasonably fear being hailed into court for issuing an advisory opinion that condoned proposed activity. And that is the kind of opinion that is valued by the Supreme Court for actually benefiting and preserving First Amendment rights and ensuring that the Hatch Act does not violate federal employees' First Amendment rights. Where the Office of Special Counsel went wrong here is they did not merely provide a safe harbor for employees and say what they could say. They went beyond that and threatened adverse action if they engaged in other activity. For instance, they explained that there is a presumption that the use of the term resist without anything else was political activity. And that is a threat, in our opinion, of future adverse actions to federal employees. With respect,
well, I mean, maybe so, maybe not. I don't know, but the whole ripeness thing is the facts in this whole thing just haven't gelled to the point where you have a justiciable controversy. I mean, this is mootness and ripeness are really crucial elements to judicial restraint and to keeping courts within the bounds of their own jurisdiction. And, it seems to me you're trying to lead us into the advisory opinion business, which is the very thing you complained about. And it's very flattering for you to think that we could provide some crystal clarity to all of these myriad questions that arise during the course of Hatch Act implementation. But I have to tell you, there's some judicial opinions, unfortunately, which are every bit as vague, if not vaguer, than what you're challenging here. And so it seems to me you're asking us to contribute to the very infirmity that you're challenging, and all without a concrete bed of facts. I mean, I always thought a lawsuit was to apply the law to the facts. And I don't know what the facts are here. It's all in the realm of conjecture. And that was what concerned Judge Zennis.
Yes, Your Honor. It appears that my time has expired, but I would like to briefly respond.
Please do.
Yes, Your Honor. Our position in this case is that the case is right because federal employees should not be forced to risk their livelihoods in order to speak. You speak here about whether or not the advisory opinion actually provided was vague enough, perhaps, to provide a justiciable controversy. But the principle here is about whether the federal employees would face a reasonable chilling effect. And the principle that
you can raise that question at a later point, and you can raise that question if the MSPB is prosecuting. You can raise that question there, and you can raise that question before the before the Federal Circuit, and there are plenty, and there are plenty of times to raise that, but I think the idea that people are they're risking their livelihoods because they express their political opinion, that rarely happens. I mean, we're talking about I think we're talking about a very theoretical risk.
Your Honor, the precedent in this circuit is that government action will be sufficiently chilling when it is likely to deter a person from ordinary firmness from the exercise of First Amendment rights. And
that's right, but that they weren't dealing with a highly reticulated scheme, such as Congress has set up this scheme, and they passed the Hatch Act for a reason, and that is so that the people of this country could have a degree of confidence in the impartiality of the federal workforce. And it was a big deal when the first one of these acts, the Pendleton Act, was passed in 1883, and it was the signal accomplishment of Chester Allen Arthur's presidential term. But the concept has lived on, which is that in return for the privilege of public service, people are willing to accept a degree restriction upon their normal liberties. There's nothing wrong with that. When those of us here and on the Fourth Circuit agreed to go on the Fourth Circuit, we were grateful for that privilege, and we agreed in exchange for that privilege to give up partisan activities. It's simply a restriction that we accept in order to give the public confidence in the judiciary. And much the same concept is at play in the Hatch Act. And I must say the relevance of the Hatch Act does not seem to me to have faded, because with all of the allegations that one reads regularly about partisanship in the Commerce Department and the Internal Revenue Service and the FBI and the Labor Department and everything, there is a greater need for a public service that people can trust as working generally for the public welfare and not consumed by partisan factionalism. And that's important to giving people a sense of faith. And to be sort of jumping in at this very premature stage and fiddling around with the Hatch Act enforcement scheme, and doing what seems to me to be this specially designated business or congressionally authorized docket of a sister circuit. As I say, come back to what I said, I think we are crashing a party. May not be a party, but we're crashing something. But, I just like to lay bare what I think you need to know. I don't speak for anybody else, but I think you need to know what my reservations are. I think I need to be honest with you about that, and let you respond. You tell me why I'm just wrong not to be concerned about this. Why I'm wrong to be concerned about this, about the Hatch Act's overall purpose of trying to preserve some semblance of impartiality on the part of our federal workforce. Am I wrong to be concerned about that?
Your Honor, I do think you were wrong in the sense that while the Hatch Act was enacted to prevent partisan discussions in the workforce, the issue here is that the advisory opinion issued by the Office of Special Counsel goes beyond partisan activity. And Congress was also clear in the Hatch Act that federal employees do not lose their First Amendment rights, and those rights are meant to be preserved to the furthest extent possible. And our issue, as you mentioned, there is the opportunity to challenge this policy in front of the MSPB and potentially in front of the federal circuit, but that opportunity only arises after a federal employee has been faced with prosecution and forced to go through that ordeal. It is our position that federal governments should not be forced to go through that process in order to enforce their rights to speak.
Well, maybe you should take that up with Congress. At any rate, you have some rebuttal time, and I'm happy to have my colleagues raise questions with you if they have some. Judge Traxler, would you like to ask counsel some questions?
No questions right now, thank you.
All right, Judge Rushing?
No, thank you.
All right. All right, let's hear from Mr. Starker.
Your Honors, and may it please the court, Jack Starcher on behalf of the Office of Special Counsel. Plaintiffs have made clear throughout this case that their challenge to this advisory opinion sprung from the alleged chilling effects that opinion had on their members and their members' desire to comment on certain topics covered by that advisory opinion. As has been made clear today, there's no dispute before this court at this time that the speech that plaintiffs' members say that they want to engage in is no longer chilled by this advisory opinion, because this advisory opinion by its terms no longer applies or covers the speech that they wanted to engage in, even assuming, as Judge Wilkinson pointed out, that speech was covered at some time in the past. Plaintiffs' only responses on mootness are first to propose a number of hypothetical future cases in which it is possible to imagine a future live case that presented a live controversy to this advisory opinion or some future similar advisory opinion. But this court's case law and then the Supreme Court's case law around mootness make clear that mootness cannot be overcome merely by presenting hypothetical future facts that don't currently exist and might never come into existence. And plaintiff's second response on mootness, which is to invoke the voluntary cessation doctrine, simply doesn't apply here. This is not a voluntary cessation case. This is not a case where OSC made a decision to stop pushing forward with or holding out some regulation or policy. The change that mooted this case is a change that happened in the real world, separate and apart from any activity or decision made by OSC. And that change is that the 2020 election occurred, and all individuals who were candidates for that election no longer are candidates for partisan public office, which is the key on which this question turns. So for those reasons, that this case is moot, and we would ask this court to dismiss it as such. I'm happy to take any questions if the panel has questions for me.
Well, the voluntary cessation doctrine doesn't apply to the situation where events have forced a change of some sort. That's what you're saying?
That's right. This is voluntary cessation occurs when the defendant usually,
when somebody just elects as a strategic matter to duck out of the case because they think that they're facing an adverse ruling. But that isn't what's at play here.
That's right. One of the concerns that undergirds voluntary cessation is the fear that defendants, will, in view of litigation, make a decision to strategically stop doing something that they are then free to restart at any time. There is nothing like that here. And of course, this advisory opinion is not free to restart, quote unquote, at any time, because the state of the world has just changed. And so there's, the OSC cannot chill this speech anymore under the Hatch Act because of the
apart from the questions of mootness and rightness, are we the proper forum to be hearing this?
No, I think this is one of many points that the DC Circuit recognized long ago in O'Connor, and I think it remains correct that the nature of Congress has created a scheme here. It is a comprehensive scheme that ultimately channels these sorts of Hatch Act violation issues through the Merit Systems Protection Board, the body that has the actual authority to conclude whether or not any conduct does or does not violate the Hatch Act, and then from the Merit Systems Protection Board through to the federal circuit. And so I think that was one of several points that the court in O'Connor made, and that the district court here echoed as to why it is inappropriate, sort of as a categorical matter, for these kinds of advisory opinions to be reviewed by a district court under a constitutional First Amendment chilling or APA type challenge.
I mean, I'm just wondering about the broad implications if every advisory opinion issued by some agency or board is going to be, challengeable like this. What are the implications of it? I mean, does that have what about I suppose an IRS advisory opinion may be different and everything, because you're not dealing with an alleged First Amendment claim, but there was still, I think, of all of the different advisory opinions, and if we would want to be cautious about saying that they gave rise to a justiciable controversy. I mean, that it could be quite far-reaching.
That's exactly correct, Your Honor. And, as noted, that the Supreme Court, in upholding the constitutionality of the Hatch Act in this very context, noted that one of the reasons why the Hatch Act is constitutional is because of the availability in the Hatch Act scheme for federal government employees to seek advice from the Office of Special Counsel. And if the Office of Special Counsel advises that certain speech is acceptable or is not violative of the Hatch Act, that provides a safe harbor. So it's not just that provides comfort, that provides, in fact, legal protection against liability. And as you suggest, I think that this case really demonstrates those sorts of concerns that you raise. This is a small office within the Office of Special Counsel. They issue, over 1,000 of these sort of advisory opinions every year. If you think about the nature of these advisory opinions, a great number of them conceivably could be, you could say, oh, well, this has to do with speech, therefore there's First Amendment, challenges sort of in the ether. And so if every one of these advisory opinions was suddenly subject to First Amendment challenge in a district court, there's no way that this office, which again is—
So what do we do to the congressional enforcement scheme?
And then on top of that, right, there's that would totally invert and create a separate sort of parallel scheme that would exist in federal district courts running through the courts of appeals writ large, where you have an express, intent expressed by statute for these kinds of issues, questions about whether or not conduct violates the Hatch Act, for those issues to be channeled through the Merit Systems Protection Board and through the federal circuit. And so I think that's an additional problem.
One of the that's just impressions I've had, and I'm not, maybe my impression is wrong, but my impression is that OSC and Jack generally is moving in the direction of giving federal employees greater speech rights within the office. That maybe doesn't go so far as to say advocacy. Probably can't go around soliciting funds or plastering bumper stickers all over your desk and proselytizing federal employees or your fellow employees. We have a rule, incidentally, in our courthouse that we don't want people who are employed there and in the parking lot to run around before election time with all kinds of buttons and partisan bumper stickers and the like. But still, we would want employees to be able to discuss the issues in an election, and that's very constructive. I mean, because they don't share their citizenship once they work for the federal judiciary. But my feeling, my sense of it is that the OSC and the MSPB are moving in the direction of allowing greater political expression. And I don't want to do something that would choke that up, or choke that off, because of the fear on the part of OSC that if they issued one of these advisory opinions every time they did so, they were going to be hauled into court. And so every time you can just see the office discussions going on, well, maybe we ought to issue this advisory opinion to let federal employees know that they can do this and engage in this kind of activity and that it's a safe harbor. And then somebody else in the room says, "Oh, no, don't do that. You're going to give rise to a lawsuit. Now let's just keep our head down." And you could really erode something that is a very, by and large, is a useful practice. Isn't that a risk?
I think that's exactly right. And as you say, I can't speak to any broader trends in OSC's, desire to be more or less restrictive here, but it is certainly correct that if these advisory opinions are ripe for judicial review in a district court on sort of First Amendment challenges, that is going to have a negative effect on OSC's ability and desire and willingness to respond to questions by members of the federal government who are usually reaching out to OSC, genuinely looking for advice and comfort and guidance. And it would be, I think, problematic and would perversely, result in greater chilled speech if OSC
the great laws of unintended consequences, huh?
I think that's right. Yes, Your Honor. If there are any further questions, I'm happy to answer them. But otherwise, I ask this court to dismiss this case as moot.
Mr. Starcher, this is Judge Trax. I had a question to ask you.
Sure.
If we were hypothetically to feel that the law would, in the First Amendment area, would be applied differently to OSC and to those employees covered by the Hatch Act, what legal principle would we rely upon to justify different treatment from your normal opinions issued for implicating First Amendment rights issued by other agencies? How would what legal principle could we base our distinction on?
I think ripeness is the right principle there, and specifically, it's the idea.
No, it can't be right. There's got to be some other justification for why this area, this group, this department or agency gets treated differently from other federal departments or agencies that also issue opinions or rules regarding that affect First Amendment rights.
So I suppose one place the court could look is the Supreme Court's decision upholding the Hatch Act, and to just make note of the fact that this entire statutory scheme, has always from the beginning raised sort of special First Amendment concerns, and that the Supreme Court has, and other courts have repeatedly upheld the existence of the Hatch Act, which again necessarily implicates First Amendment rights of federal government employees, on the basis and the justification that federal government employment is a choice. It's something that there's sort of an implied agreement when federal government employees accept the privilege of being a public servant. Part of what comes with that privilege is the corresponding obligation to while on duty as a federal government employee to give up the ability to speak in certain ways. So I think to the extent that the court were to want to create a rule specific to OSC and the Hatch Act, I think that within the context of the First Amendment, I think that rule already exists and is implicit in letter carriers being the sort of seminal Supreme Court case, recognizing that this context is different from contexts that are not federal employee specific.
Okay, thank you. That answers the question I asked.
All right. Judge Rushing, did you have any further questions? Or?
I don't. Thank you, Judge Wilkinson.
All right. And counsel, we're happy to hear from you in rebuttal.
Yes, Your Honor. Thank you. I'd like to first briefly address mootness. OSC has a heavy burden of establishing mootness, and in fact, they had an opportunity to do so while this case was on appeal. Appellants agreed to dismiss this case as moot if the OSC, in writing, pledged not to prosecute any of appellants' members for violations.
But I don't understand how the voluntary cessation doctrine applies here, because after the election, you had a wholly different set of circumstances and a wholly different sort of cast of characters and a different set of issues. The resistance being one, and a second one being the impeachment proceedings. And why is it not a reasonable thing for the OSC to issue an opinion, an advisory opinion, which addresses itself to those circumstances?
Your Honor, with respect to impeachment, circumstances certainly did change. However, OSC's rationale in preventing the use of the term resist was that the term was intricately linked with the Democratic Party, And if that's the case, that did not change after the election. The term would be just as linked to the Democratic Party as it was before the election, and its use would be political speech. But moreover, there is a second reason that this case is not moot, and that is that plaintiffs' members still face some risk of prosecution. A case is not moot as long as a court can provide any effectual relief. And protection for any one of appellant's 600,000 members would be effectual relief in this case. Now, I would like to move to briefly discuss the arguments on ripeness. I would first say that this case Judge Rushing, do you have a question?
No.
No, I don't have a question, no.
Sorry, Your Honor, I saw the light flash, so I didn't want to interrupt.
I don't know, there's something going on with the lights. I'm not sure what it is, but I appreciate very much your courtesy in pausing, but please go ahead.
Yes, Your Honor. I would simply say that the question in this appeal is very narrow, and it is whether this claim is ripe. And the structure of the Hatch Act and the system that Congress set up is the value of the Hatch Act is not at issue. The question is whether government employees can ever challenge an opinion by the Hatch Act threatening prosecution for expressing First Amendment rights. If the answer is no, then there is no reason to limit that principle to cases here where it might be, in your opinion, Judge Wilkinson, borderline. The OSC could issue an opinion that says that any discussion of any government policy—
Well, you can't, to say you can never challenge it, you certainly can challenge it before if in the unlikely event, and I can't imagine it, that the MSPB were to initiate a prosecution because someone had expressed an opinion on impeachment, you could certainly raise it defensively, and it would probably be dismissed the prosecution would probably be peremptorily dismissed. But you can challenge these things, I think, all the time. There are informal ways of challenging this kind of thing, and to raise questions within the agency and say this doesn't make sense, and all the ways. I mean, every doesn't have to be an actual courtroom challenge. Many times rules and opinions are changed through internal deliberations. All right, so that's another way you can challenge it. A third way you might be able to challenge it is that if you, in addition to defensively before the MSPB, in addition to internal discussions and dialogues, which very often produce changes that the litigation is designed to bring about. And the third way you can challenge it is if there was something more concrete, maybe, before us. But I think this was what plagued Judge Zenas is, we just don't know, what speech is there, what sanctions are imposed, I think the phrase your opposing number issued was talked about was in the ether. And, at some point things become abstract to a certain degree that you just, as a court, you feel a little bit uncomfortable getting into it, because you just say, this is abstract. And it's sort of there's an irony, isn't there, counsel, that in an effort to challenge an advisory opinion, you're asking us to issue something that might resemble an advisory opinion? Isn't there? And maybe the term is irony, or maybe the term is paradox, but isn't that present?
No, Your Honor. We are not asking the court to issue an advisory opinion. And in this appeal, the only thing we are asking is to find that this case is right. This is a pre-enforcement challenge, and there is no other way. There is no method to bring a pre-enforcement challenge to the MSPB. Under the principle that you are expressing here, Your Honor, federal employees would have no choice but to risk their livelihoods before they can speak. And that is not, as Judge Traxler mentioned.
No, what I'm saying is, I think that if you say that the minute an opinion, the minute an advisory opinion is issued, that just on the basis of that and sort of speculative and conjectural assumptions about what might follow, you can automatically go into federal court with a pre-enforcement challenge, even though that the facts have not gelled beyond a very abstract level. And if we opened up advisory opinions to that extent, given the prevalence of the practice throughout the federal government, I think it puts the courts in an awkward position vis-a-vis the executive branch generally, and more specifically, as opposing counsel has recognized, we run a real risk of doing real damage to the congressionally set up scheme, which the Supreme Court has said has blessed and has not, the Supreme Court has had plenty of chances through the years to say that the Hatch Act is unconstitutional in some sort of way, but they haven't done that. Even after all these years, it's still the books, and Lord knows there's been no dearth of challenges.
Yes, Your Honor, but those challenges were not dismissed for lack of ripeness. They were dismissed, and this case was not dismissed on a 12b6. Opposing counsel mentions the Supreme Court's decision in letter carriers as a reason to, create new First Amendment law for federal employees. But this case was not dismissed because a challenge to the Hatch Act is not a claim.
Oh, but that's what's underlying it.
Well, Your Honor, that would be a different conversation than ripeness. Ripeness in this circuit can be established by self-censorship, a reasonable fear of adverse consequences for speaking. And yes, Your Honor? I
would just say to you that the boundaries of that ripeness and mootness are not infinitely elastic.
Yes, Your Honor, of course, but the question here is a reasonable fear of prosecution, such that an employee would refuse.
Well, if the question is a reasonable fear of prosecution, they've just issued an advisory opinion that says you can do it. So how is there a reasonable fear of prosecution right on the heels of an advisory that says this is permissible activity? If that's your formulation, that just collapses under the particular facts and given the particular opinion that OSC has just issued, huh?
Well, Your Honor, we have found no cases where activity performed by the defendant after the commencement of a case can make an otherwise ripe case unripe.
Sure it can. I mean, we have an obligation to assess ripeness, our own jurisdiction as it stands today. And the Supreme Court has indicated, since the 70s, the Supreme Court has talked about ripeness is time sensitive. It's evaluated at the time of decision. So, the question is the policy that's in place now and whether your clients are chilled or have any claim now when we're assessing ripeness.
Oh, Your Honor, we would contend that we still have a credible threat of prosecution. Plaintiffs, employees, over 600,000 of them, for speaking while the policy was in effect. There has been no opportunity.
Where's the allegation about who spoke and why they are fearing prosecution? What did they do that's going to come within the parameters of this policy?
Well, Your Honor, plaintiffs filed everything necessary to make their claim at the time the case was filed. It would be improper to file affidavits in an appeal to make that case now. If this court remands back to the district court.
There's no evidence about in the record. There's no, or not evidence, but there's no even allegation about, someone did X, and that would fall within the parameters of the policy. It was all
Not-
it was all forward looking, and I'm not faulting you for that, but it was all forward looking. We want to do X, and we think it might be prohibited.
Yes, Judge Rushing, all the allegations in the complaint were forward-looking, and there is no specific evidence in the record that employees have already violated the policy.
All right, we thank you both. I think we'll adjourn court, and I very much appreciate your respective arguments in this case. And we will adjourn court and go into conference.
This honorable court stands adjourned until tomorrow. God save the United States and this honorable court.
I will put the judges into the breakout room.